At the end of the daily docket in the Greenwood County Magistrate Court in Eureka, Kansas, courtroom cameras captured Judge Phyllis Webster and County Attorney Jill Gillette discussing several individuals who allegedly failed to appear for their scheduled court date. During their conversation, Judge Phyllis discovered that a procedural error had left her unable to take action against the individuals who did not appear in court and implied that the county attorney's office may be the source of the error. Ms. Gillette's response to Judge Webster's remarks prompted a heated exchange that very well could have placed her career in jeopardy.
Tanya Sanchez.
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours, and then Lyon County come and got him before.
I noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
okay, well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster argues that she cannot take action for the defendant's failure to appear without any filed evidence showing that the defendants received notice that they needed to appear in court. Generally, when an individual knowingly fails to appear for a scheduled court date, judges have the authority to issue a so-called bench warrant for their arrest. For instance, Section 19-4739 of the Kansas statutes authorizes judges to cite individuals charged with county code violations who fail to appear for a court date with contempt of court and issue a bench warrant. However, this statute only allows the judge to take these actions if the defendant fails to appear, now quoting from the statute, after service of notice to appear. Although we do not know the details of the charges against the individuals who did not appear at their court dates, notice of the requirement to appear in court is essential to proving that an individual knowingly disregarded that requirement, and it is more than reasonable that Judge Webster refused to take action without any evidence of this notice in the defendant's files.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well, I
can print you off the copies that I got sent.
copies. I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so...
Well, even with the long form, I would accept You don't have the originals, Arlene? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why?
Well, because that's the clerks.
Well, Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets. And I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
If I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Miss Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. In fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant, and you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
my secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss Gillette, you are not listening to me, and you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Ms. Gillett claims that prosecutors are quote-unquote immune from being held in contempt of court, and Judge Webster reminds her that she also has ethical obligations as an attorney. As the Supreme Court determined in the 1976 case of Imbler versus Pachman, state prosecuting attorneys acting within the scope of their duties and initiating and pursuing criminal prosecutions are absolutely immune from civil lawsuits for damages. In reaching this conclusion, the court reasoned that, quote, To be sure, this immunity does leave the genuinely wrong defendant without civil redress against a prosecutor whose malicious or dishonest action deprives him of liberty. But the alternative of qualifying a prosecutor's immunity would disservice the broader public interest. It would prevent the vigorous and fearless performance of the prosecutor's duty that is essential to the proper functioning of the criminal justice system. However, immunity from civil lawsuits, which shield prosecutors against legislation from defendants who believe they were wrongfully charged, does not logically extend to protecting prosecutors against being held in contempt by a judge for misconduct in a courtroom. Section 20-1203 of the Kansas statutes grants judges the authority to punish individuals for quote-unquote direct contempt, which Section 20-1202 defines as, quote, contempts committed during the sitting of the court or of a judge at chambers in its or his presence. There is no language limiting this power to everyone in the courtroom except the prosecutor, and courts have long recognized a judge's power to hold attorneys in contempt for their conduct. For instance, in the 1877 case of In re Pryor, the Supreme Court of Kansas held that an attorney may be punished for contempt by insulting or disrespectful language or conduct in the presence of the court. The court noted that, quote, an attorney is under special obligations to be considerate and respectful in his conduct and communications to a judge. He is an officer of the court, and it is therefore his duty to uphold its honor and dignity. The independence of the profession carries with it the right freely to challenge, criticize, and condemn all matters and things under review and in evidence. But with this privilege goes the corresponding obligation of constant courtesy and respect toward the tribunal in which the proceedings are pending. A failure to extend this courteous and respectful treatment is a failure of duty, and it may be so gross a dereliction as to warrant the exercise of the power to punish for contempt. Now, I could not find any case law promoting Ms. Gillett's assertion that prosecutors are quote-unquote immune from contempt, but she did state that she had quote-unquote briefed the matter, which indicates that she at least has a colorable legal argument supporting her position, and I would be interested in reading this brief and learning her reasoning. However, even if state prosecutors are immune from contempt in Kansas, as Judge Webster pointed out, attorneys are also subject to certain ethical obligations regarding their behavior in court, and may be punished for their conduct if it violates ethical rules. According to Rule 3.5d of the Kansas Rules of Professional Conduct, quote, a lawyer shall not engage in undignified or discourteous conduct degrading to a tribunal, referring to the court. Therefore, Ms. Gillett's behavior towards Judge Webster could potentially subject her to discipline for violation of the rules of professional conduct.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Ms. Gillette. At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
It is unclear whether Ms. Gillette faced any disciplinary action, but she has since appeared in court on good terms with Judge Webster. This interaction highlights that although prosecutors are entitled to some degree of judicial immunity, they are not impervious to consequences for acting in bad faith, and they must abide by the procedural and administrative aspects of the judicial system as much as anyone else participating within it. I commend Judge Webster for refusing to issue warrants for citizens she didn't believe she had the lawful authority to have arrested. Although the judge knew that the information Ms. Gillette relayed was likely reliable, she forced the prosecution to fulfill their administrative duties before proceeding with the warrants, and did not offer any deference to the government that she wouldn't have offered to the citizen. It is important to note that one small outburst does not define Ms. Gillette's character, and nothing in this episode is meant to suggest that she is incompetent or unqualified to act as a county attorney. Procedural errors are a frustrating aspect of many jobs, and while that doesn't necessarily excuse Ms. Gillette's outburst, it should serve as a reminder that we've all been there in one form or another, and none of us are immune to having a bad day at work. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.